Somebody should make photos. I need them. And you can send it.
Vogliono anche la documentazione fotografica.
Alla sinistra, alla sinistra. Nem pojma, Marko. Da, to je dobro pitanje. Marko, you have to introduce me, present me. Sì.
Esatto, dopo affezione. Anzi, diciamo,
Pusti ga sad, guardate.
è stata una specie di
No, ok.
Guarda che avevo posto.
And
il controllo.
very uncomfortable. I do not see people when I thank you. Then I will move later. Malo, Ivana, samo tamo malo dok sam ja posjeću, I will move when I finish. Huh? No, I only need now people to see, to be in the context. And this prevents me, this screen. Just say who I am, because I don't want to say by myself who I am.
No, that's it.
I will have double N. And yes. Yes.
Good afternoon to everybody, and welcome to the 5th multiplier event of the LAWGEM project. Multiplier event is intended to share the outputs of the project, and in order to widen the activities that have marked the project as a whole. I'm very proud to give the floor to Professor Dragica Vujadinovic, who's professor in Belgrade University, is the head of the Master European Integration, is the coordinator of our project. Dragica, the floor is yours.
Thank you, Marco, very much. I'm really pleased and honored to be here at LUMSA University, and also have some kind of, not obligation, but a good purpose is that we, for the purposes of dissemination of this project, say not just a few words. Let me tell that I will speak maybe about, I don't know exactly, but half an hour is planned for this presentation. I will not exceed, but so that will be devoted to this aim. Strategic partnership in strategic partnership in higher education. Erasmus Plus strategic partnership in higher education is the general title for this type of grants which European Commission delivers, and we managed to get this grant with the project titled New Quality in Education for Gender Equality. Strategic Partnership for the Development of Master's Study Program, Law and Gender. So that's the aim, developing this new master's study program. The duration was proposed to be from October 2019 to August 2022. Due to the COVID outburst, we got the permission to prolong the duration until December 2022, and this is the last event going on within conducting this project. So 5 consortium members have been working together since a long time ago, and these consortium members really have done a lot together. And they are Cadiz University, LUMSA University, Saarland University, then Orebro University, Belgrade University. As I already mentioned, COVID-19, the working conditions really were very often horrible. Many of the people belonging to the project did experience COVID illness, but I must say that contradiction or discrepancy between bad working conditions and the devotion, diligence, and of course the end results of the project it has been huge. In short, we did everything what was planned to be done, and we did much more. And you will see from my short presentation what everything is or has been on this agenda. So first, of course, we had 5 conferences. The first one was in Belgrade, the kickoff conference. Then, due to the COVID conditions, we had to hold 2 conferences online in Saarland and Cadiz. And afterwards, in May 2022, we were together in Orebro and held our conference, and this is the last one, as I said, in Palermo. Due to the mentioned bad conditions and COVID context, we organized additional conferences. For example, learning, teaching, training workshop, which has been combined with this last conference, and which is held here in Palermo at the end of the project duration, was planned for May 2020. So we postponed, and finally have been holding that here. But instead of that, because learning and teaching for building the new curriculum, gender perspective, gender competent legal knowledge curriculum, or reconsidering of fields of legal education from the gender equality perspective, demanded learning and teaching new experience. So we used these online conferences. One was called Gender Competent Legal Knowledge. May 2020, I made mistake, and 2 online plenary sessions devoted to syllabi, curriculum, and one of the very good conferences held in Belgrade in a hybrid way. Then we dared to organize that also in live, was held in September 2021 and devoted to the issue of gender inequality of women and girls with disabilities. So very shortly, 5 intellectual outputs were proposed, and all of them have been done. This curriculum for law and gender master study program, then empirical survey tool. As a matter of fact, we did empirical survey related to the institutional setup from the point of gender inequality, discrimination, or already achieved equality on all our consortium faculties and universities. And also in the survey, we included many questions related to the system of values of professors, stereotypes, prejudice, etc., etc. The main, I would say, the main output of this project, besides the curriculum, because the textbook would not be possible to be written without outlines and guidelines which the curriculum gave. So that's the textbook, and I will speak mostly about the textbook. Then we also built a gender equality legal clinic, which wherever and whenever this master's program will be conducted, it will be also part of that curriculum. And of course, something what has been becoming self-understandable is that you have platforms for disseminating and for the follow-up and for presenting all the results during the project duration. That's the lifelong learning platform. You really can have a look of everything at the platform of the LAWGEM project. It's easy to find, but also at this lifelong learning platform, which is even much richer than the project platform, which is supposed to announce intellectual outputs. But the lifelong learning platform has even a wider outreach with different recorded lectures, sources, etc., etc. So the textbook done by the LAWGEM team from these 5 universities and edited by Thomas Gigerich, Mareike Fröhlich, and myself as the co-editors. So, and very interesting, I did count, I did not know by heart that so many authors took part, but I counted them. So 72 authors there are of 19 chapters from 5 consortium partners. I mentioned who are the consortium partners. And definitely the aim is to present gender sensitive, the aim of the textbook is to present gender sensitive and gender competent reconsideration of all relevant fields of legal and multidisciplinary knowledge within legal education. And we use both of these terms, gender sensitive and gender competent. Gender sensitive in a sense being open for reconsidering everything, for being being sensitive for this new approach, and then to go further on and to offer competent knowledge from gender perspective. So these are 2, how to say, complementary adjectives used to make better insight about what we aimed at. So I will read a few statements of us, 3 co-editors of the book from our introductory chapter written for the textbook in regards of this, what I said. And later on, when I will mention what is the content of the textbook, I will again read what we wrote in short and in a summing up way about all chapters, because I think it would not be fair if I used only my interpretation, because we did it together, 3 of us, and on the basis of everything what the others have done. So I thought it would be fair. So I will, you will see later what the three of us said about these all chapters. So academic scholars from universities across 5 different countries were involved in writing this book. Such successful teamwork gives the text a specific quality and is an unprecedented academic phenomenon. Working at different universities, primarily at faculties of law, but not only, researchers accepted to investigate and study feminist critical legal and political literature, reconsidering from a gender perspective their various fields of academic research and teaching and their academic backgrounds. So we cannot say that all of us had this feminist critical thought in advance feminist background. So the goodwill was to a great extent involved. The research and teaching project that produced this book represents an extremely exciting, innovative, and challenging academic undertaking. Individual academics of different educational backgrounds, very different religious, political, cultural, social, historical heritage, and independently of possible binary or non-binary gender orientation, who had not known each other before, readily took up a huge effort with a common and unique aim to reconsider and deconstruct legal knowledge in order to articulate gender-competent understanding of the law and related disciplines and reconstruct them accordingly. These intellectuals managed, or scholars managed, in spite of all their differences, limitations, and obstacles, to establish a culture of dialogue, readiness to share research and writing duties, to open their minds to new insights and the potential to overcome their own gender-based biases. Accordingly, the chapters have been built as the real teamwork result. That's very important. So authors for each chapter, we had from 3, sometimes even 5 authors from different consortium partners. And just to add this, what I put into this slide at the end, this textbook is the pioneering undertaking, but it is not the final word. That is very important to say, to be humble, to be, how to say, open for further work and maybe for critiques related to what we have already done, because we did something as the background and the basis and as the boosting effort for the others to go further, better, and etc. So that was very important for me to say. So I will just go fast through the titles. I do not give you a time to read the titles, but I will speak a little bit more about the chapters, as I said, from the introductory word. So after introduction, we have the general approach, then gender in a public content, national context, private law context. And now I will go on and say that we start the introduction with the key findings of the Global Gender Gap Report from 2021, which says that on its current trajectory, 135.6 years would be needed to close the gender gap worldwide. We also point in the introduction to the fact that the male-dominated law has almost completely characterized the whole pre-modern history of law, and that even nowadays in the modern law, the gender-blind approach to legal issues has been dominant within most legal fields. So the LAWGEM team's attempt with this textbook is insofar to contribute to fastening the change in the current gender gap through boosting changes in higher education. So education is our target in this, what I said at the beginning. Especially legal education. Differently said, the whole project and the textbook attempt to contribute to introducing into law and legal education the substantive equality or gender equality approach, because formal equality far too often masks deeply rooted gender inequalities. I quote here the author Friedman, but that's our approach. So this textbook will be titled Gender Competent Legal Knowledge, will be published in October. E-book will be published in October. Springer publishes that book. And I don't know exactly, very soon after it will be published also in hard copies. And it will not be, how to say, only the really textbook purpose use of this textbook, because besides students, it can be relevant and interesting source for learning and teaching for the scholars worldwide. And as a matter of fact, it will be, how to say, published for purposes of worldwide distribution. So now I will speak a little bit more about all chapters. In essence, the textbook is structured in 3 major parts, which deal with the gender perspective in different contexts. The first part, gender in a general context, focuses mainly on explanatory contributions which help to understand the following chapters in a better way. The second part organizes all chapters in the context of the public sphere, differentiating the European and international level from the national one. It analyzes the gender perspective in the field of administration, planning, and politics. It also includes criminal law issues as part of the public life. In contrast to this, the last part deals with the private dimension of the gender perspective, especially in private life, economy, and business, as well as in the world of labor. The first chapters want to set the ground for gender competent legal knowledge. Therefore, the chapter on gender issues in comparative legal history gives a historical overview of gender issues and the domination of the patriarchal system in the Western legal systems from the antiquity to modern times. The different feminist political and legal theories have been introduced and critically analyzed in the chapter Feminist Political and Legal Theories, which also considers the necessity of reconsidering old political and legal concepts from the feminist perspective and introducing the new ones which better inform the political and legal knowledge about gender equality, importance, and content. The chapter Gender and Structural Inequalities from a Socio-Legal Perspective focuses on structural gender inequalities in private and public social spheres, especially education production, labor market, and media, by deconstructing the gender binary system. The important role of gender in the judicial decision-making in the context of the composition of the bench has been analyzed in the chapter Feminist Judgments, which also highlights a few projects to overcome the effects. In the introductory part of the textbook, just to add, the chapter Gender Research and Feminist Methodologies deals with ontological and epistemological approaches and explains how to conduct research with a gender equality perspective. The chapters on human rights law through the lens of the gender perspective and the evolving recognition of gender in international and European law explain the international and European framework for gender protection and mainstreaming. The first addresses the different aspects in human rights law and discusses, among others, the prohibition of gender-based violence, slavery, and human trafficking, the freedom of religion, as well as women's access to justice and education. The second one explains the different legal sources for fighting gender-based discrimination and gender mainstreaming, and puts special emphasis on the UN Charter Convention on the CEDAW, European Charter of Fundamental Rights, European Convention on Human Rights. The national public perspective, promoted also by international instruments, will be examined in the chapters on gender equality aspects of public law. The chapter deals prominently with the underrepresentation of women in governmental and state institutions and introduces a multi-layered approach of gender empowerment to raise the impact on public policies. The role of governments to secure the social welfare of citizens and gender equality has been addressed in the chapter Gender Perspective of Social Security Law. This chapter introduces especially cases where discrimination due to the different nature and roles of women and men takes place. Gender equality in the public expenditure management as well as the national taxation laws have been analyzed in the chapter Gender Equitable Taxation, and tries to point various ways of gender discrimination within a household, at the workplace, and within the broader economy, denying the principle of fairness. The role of public engagement is reflected in the chapter Public Policies on Gender Equality, and introduces different ways to support gender mainstreaming and impact assessment of public policies. In the aftermath, key gender-sensitive policies in different sectors are elaborated. The general and special part of criminal law, which deals with gender discrimination and gender-based crimes, is explained in the chapter Gender Competent Criminal Law. It focuses mainly on the Istanbul Convention, but also examines the general theories of criminal law in the light of gender equality. The chapter Gender Perspective of Victimization, Crime and Penal Policy shows the criminological perspective regarding the relationship of crime and gender. Data is evaluated to explain the ethological background, the awareness for gender victimization, and the penal policy of courts facing different genders. In the last part of the textbook, the chapters deal with gender issues in the private context. A main overview of gender discrimination in private law is found in the chapter Gender Equalities in the Different Fields of Private Law. The focus is on property regulations, freedom of contract, and tort liability. The context of family law is analyzed in the chapter Gender Competent Family Law, and there is firstly explained the genesis of the family throughout the history and up to multiple forms of family and social relations within families of today. It then examines the interplay of rights and responsibilities of partners, parents, and children, and its impact on gender equality, including also marital contracts. Finally, it also addresses the important topic of domestic violence. Gender discrimination, as being widely spread in labor relations, has been elaborated in the chapter Labor Law and Gender. The chapter covers different relevant dimensions, like as protection against gender-based discrimination by the employer, women empowerment, and gender-based discrimination during the hiring process. The economical aspects of gender issues are dealt with in the chapter Integrating Gender Equality in Economics and Management. There is explained the theory of feminist economics, within which are taken into account gender indicators, gender parity, gender equality, and gender mainstreaming. There are also examined in the light of gender, the managerial and innovative sides of economics. The last chapter, Gender, Business and the Law, deals with gender aspects in the business and economic world. It explains not only the impact of gender diversity in company boards or in dispute resolution boards, but also how women's economic empowerment is supported by various initiatives. One main actor is the European Union, although the EU internal market has no impact on gender equality, but recent trade agreements follow a gender mainstreaming approach, which opens new possibilities for women. And just to finish, so you can see that this really was worked on very seriously and very systematically, and each chapter is closed, or before ending there are put questions which are of relevance, which open space for an interactive work with students, and which have been controversial per se. So this pedagogical, how to say, innovation not only applied here in this project, but in good, how to say, pedagogically speaking, good new endeavors and results has been applied also here. So that's it. That is about our textbook, at which we all have been really proud. And as I said, 72 people work together, and without so many good people, that kind of textbook would not be possible to be realized. Besides these, I mentioned 5 intellectual outputs which we proposed and were obliged to realized, but we did a lot more. For example, after the conference at Cadiz University, which was held online, but it did not prevent us from creating added values. The book was published, Law and Gender in Education and Practice. Professor Isabel Ribes, I can't pronounce very well her surname, who is the contact person for Cadiz University. She couldn't come here, so she's one of the co-editors. Then I mentioned the conference held in Belgrade recently on disability, gender inequality related to disability issue. And Professor Ljubinka Kovačević, Professor Marko Evola, and myself, we are the co-editors of the book, Intersectional Discrimination of Women and Girls with Disabilities. It will be published in December 2022. And something what I really have to put the biggest focus on is, so Springer published the text, will publish or has been in the process of publishing the textbook, Gender Competent Legal Knowledge. However, Springer accepted or offered to establish with us, with the LAWGEM team, the book series called Gender Perspectives in Law. As a matter of fact, during our work, we came to the idea that it is not enough to make this gender textbook, so systemic approach to, in a little bit schoolish way, but to offer to authors from anywhere to write about specific fields of law from their individual perspective and field of interest, and also as the individual authors or co-authors. And Professor Ivana Krstić, who also couldn't come here, and myself, we created the call for that book. It was called Gender Perspective in Law. And just to make it very short and to say that fast, at the end, the response to that call was more than 60 abstracts. Then we made selection. Then around 40 papers were in the process of writing. And from that, the selection ended with 36. And then we offered that manuscript, we submitted that as proposed. And then Springer said, oh, this is too good, too rich. Let us make 4 books from this. So we established, there is the book series, Gender Perspectives in Law, put into plural, perspectives in law, to open more place for different interpretations, as it is more proper approach. We firstly put gender perspective and then accepted Gender Perspectives in Law. Somebody from Orebro University suggested that, and it was accepted. So 4 books are going to be published October 2022 is promised. We will see whether also only the ebook will be published until then or hard copy. And after those 4 books, we will open calls for 2 new, and we have, how to say, the space until 2026 for many more books. And these 2 new will be Gender and Judiciary, and reassessment of feminist jurisprudence or feminist legal theories. Still, there is the talk whether to title that in this or that way, because jurisprudence has been used much more and more for feminist judgment. So, but these 2 new calls will be announced very soon, and all of you are very welcome to think about and taking part with your abstracts and your papers, because really this book series will be of a high quality, and that's important to have it. So, and Springer did a fantastic job with the legal editor of Springer, recognized that it is much more important to have the whole book series than to finish the whole thing with only 2 huge books, because this has to be the process and something what will go further on and with as many more authors as possible. So here are those books, and they're just to mention. So LAWGEM team members are the co-editors. Feminist Approaches to Law, Theoretical and Historical Insights. There are titles, but of course we don't have a time. The second book, Gender Competent Public Law and Policies. The third, Legal Issues of International Law from a Gender Perspective. And the fourth, Gender Perspectives in Private Law. So that is all what I wanted to say, and I think that our project deserves, maybe I spoke, I don't know how long I spoke, but I think our project deserves that, and thank you. I don't know how to, okay. So I will go there.
Thank you very much, Professor Vujadinovic. You spoke perfectly on time.
Really?
Yes, yes. So, hello everyone, buongiorno a tutti. Io sono ovviamente non Jesus Verdu Baeza della Spagna, ma sono Ivana Marcos da Belgrado e adesso vorrei ringraziare il professore Evola per l'organizzazione di questa conferenza. E adesso cambio. Now I switch to English. Don't worry, it will be in English. So I just wanted to say a welcome and also to thank you all for the hospitality here at LUMSA. Our first panel is on protecting women against violence from different aspects. The aspects are international law, criminology, crime in a broader sense, and also civil procedural law. We have our distinguished speakers from Italy and Sweden, and to save some time, we continue immediately. And our first speaker today will be Dr. Antonio Balsamo from the Court of Palermo, and he will speak about international crimes against women. Dr. Balsamo, the floor is yours.
Yes, I would like to express my gratitude to all the organizing institutions. It is a great honor for me to be here with you. Also because I think that the opening towards the international horizon and towards a multi-level protection of human rights in a gender-sensitive perspective appears as one of the most important features of modernity required to address the dramatic challenges of today's world, where a new basic orientation of legal education can play an essential role to reactivate that synergy between science, judicial action, and civil passion that has marked the works of jurists like Cesare Beccaria, of lawyers like Piero Calamandrei, of magistrates like Giovanni Falcone, who continue to represent the identity more authentic and stronger of our legal world in the eyes of the international community. Genocide, war crimes, and the crimes against humanity have particularly devastating effects on women, either when they are direct victims or when they witness the commission of these crimes against others, including their own families. And there has been a remarkable evolution over time in international commitment to ensure accountability for crimes against women. The international community has taken unprecedented steps to address crimes of violence against women by means of international and transnational criminal law. Despite the small number of individuals that have been tried and convicted of these crimes in international tribunals, important standards have been set that can be used as a model for domestic systems. New and progressive definitions of crimes of gender-based violence have been adopted, and the procedural rules have been introduced to remove some of the discriminatory assumptions and practices that often make prosecutions traumatic for victims and reduce the chances of conviction. Throughout history, women has commonly been targeted as victims of sexual assault during times of conflict, but the perpetrators of these crimes have rarely been prosecuted. Sexual violence formed a part of the early humanitarian law provisions in several regions of the world, and was included in early warrior codes dating from the 1st century. Rape was recognized as a violation of the law of the war, at least from the 15th century, when 27 judges of the Holy Roman Empire sentenced the governor of Breisach, Peter von Hagenbach, because he allowed his troops to rape and kill innocent civilians. But in the past, too often, acts of violence against women have been regarded as a natural consequence of war, and rape was largely invisible. For example, at the end of the Second World War, rape was largely invisible in the trials of war criminals. The crime of rape was not expressly included in either the London Charter, establishing the International Military Tribunal of Nuremberg, or in the Charter of the International Military Tribunal for the Far East at Tokyo. In fact, the term rape is completely absent from the judgment of Nuremberg, and while rape was prosecuted in Tokyo, its prosecution was considered as ancillary to other war crimes. However, overwhelming evidence of the systematic raping of women in conflicts over the last 3 decades has helped to create high levels of awareness of rape as a method of war and political repression. Often, these crimes are widespread, organized, and implemented by the ruling or rebelling regime. Systematic gender-specific crimes, including sexual assault, genocidal rape, and forced impregnation or abortion routinely occur during armed conflicts. While rape has historically been used as a weapon of war to terrify, humiliate, degrade, destroy, and subordinate, the rapes committed during some conflicts occurred in the 90s went beyond the usual. They were regularly perpetrated as part of a system of ethnic cleansing of their regions, thus needing an international response. And as a result, great steps forward have been made in the prosecution of gender-based violence. Indeed, rape and other forms of sexual violence have been successfully prosecuted as war crimes, as crimes against humanity, and even genocide by the ad hoc international criminal tribunals established to prosecute war crimes in the former Yugoslavia, the ICTY, and in Rwanda, the ICTR. As to the legal framework, it should be noted that both the ICTY and the ICTR statutes enumerated rape as a crime against humanity, and the ICTR statute additionally listed rape, enforced prostitution, and any form of indecent assault as war crimes. Furthermore, both tribunals extensively addressed sexual violence in their judgment and established important precedents. They played a key role in defining gender-based crime in international law. For example, in the case Akayesu, where the judgment was held in 1998, the ICTR noted that traditionally rape had been defined narrowly in many jurisdictions, such as in South Africa, where rape was the intentional unlawful sexual intercourse with a woman without her consent. However, the growing international jurisprudence emanating from the international tribunals indicates that the definition of rape cannot be captured in a mechanical description of objects and body parts. This view is reflected in the definition given by the trial chamber in Akayesu, the view that sexual violence, which includes rape, is any act of a sexual nature which is committed on a person under circumstances that are coercive. And the trial chamber reasoned that sexual violence is not limited to the physical invasion of the human body, emphasizing that a violation of the human dignity of a victim needs to be strongly condemned. Also the example given by the Akayesu trial is very significant. There was a specific form of sexual violence which is different from the traditional definition which was typical of several states at that time. In the ICTY, the trial chamber, in the Cele-BC case of the same year, 1998, adopted the conceptual definition of rape and sexual violence already articulated in Akayesu. It is worth mentioning also the Furunzia case, where the ICTY trial chamber held that the most important meaning of the whole corpus of international humanitarian law, as well as of human rights law, lies in the protection of human dignity of every person, whatever his or her gender. And this principle was formulated to shield human beings from outrage against their personal dignity, whether such outrages were carried out by unlawfully attacking the body or humiliating the honor, the self-respect, or the mental well-being of a person. And this innovation expanded the definition of rape in a substantial way. Subsequently, the tribunals have successfully prosecuted rape and violence against women as a genocide, such as in the Akayesu case, as torture under the category of crimes against humanity, in the same Akayesu case, and in the Cele-BC decision, and as war crimes, just like in the Furunzia case. Just for the first type of legal treatment, sexual violence as tools for ethnic cleansing and genocide. There is a clear definition of genocide contained in Article 2 of the Genocide Convention, and this definition means that rape, sexual enslavement, forced prostitution, forced sterilization, forced abortion, and forced pregnancy can all be used as instruments to impose conditions calculated to destroy the victims or to destroy their group's capacity to reproduce. In the Akayesu case, the ICTR trial chamber applied just the Genocide Convention and said that rape and sexual violence constitute genocide in the same way as any other act, as long as they are committed with the specific intent to destroy, in whole or in part, a particular group, targeted as such. The second form of legal treatment, rape as a crime against humanity. It refers to the case where the widespread or systematic commission of acts of sexual violence against a civilian population occurs, such as in the Akayesu decision, where the ICTR found the accused person guilty of crimes against humanity based on the evidence that he had witnessed and encouraged the rapes of Tutsi women while he was a communal superior. In this case, the trial chamber stated that some rapes had reached the threshold of torture. Like torture, rape is used for such purposes as intimidation, degradation, humiliation, discrimination, punishment, control, or destruction of a person. Like torture, rape is a violation of personal dignity and constitutes torture when inflicted by or at the instigation or with the consent of a public official. And such an approach was adopted also in the Furunja case, in another landmark case, that of Kunarac. In many of these cases, the criminal liability of civilian and military leaders for rape and other gender-based offenses was established by the international tribunals. In particular, the ICTR applied the doctrine of superior responsibility to civilian leaders. The trial chamber attributed the individual criminal responsibility to the accused for acts of rape pursuant to Article 6 of the statute of the tribunal, even if the accused had not personally perpetrated any sexual acts. But he was held to have acquiesced in their commission by allowing them to happen near or at the premises of which he was in control. The third form of legal qualification is rape as a war crime. It is connected to Article 3 of the Geneva Convention, to Protocol 2 to the Geneva Conventions governing the protection of civilians in internal armed conflicts, which prohibits outrages upon personal dignity, and so on. The ICTR status grants the jurisdiction over serious violation of Article 3 and of Protocol 2. And also the jurisdiction of ICTY covers war crimes. In fact, for example, Mr. Furunzia, a paramilitary leader, was convicted by the trial chamber for being a co-perpetrator of torture in violation of laws and customs of war, and as an aider and abettor of outrages upon personal dignity. Now I would like to mention the important progress made by the statute of the International Criminal Court, the Rome Statute, which recognizes the competing legal interests of the accused and the witnesses, also in some procedural rules, which establish important law provisions concerning the evidential contribution of victims of sexual violence. And in addition, it was seen as an important step towards ending impunity for sexual crimes under international law. It is worth mentioning the comment made by the former prosecutor of the ICTY and ICTR, Mr. Richard Goldstone, who, when the Rome Statute was signed, declared that gender crimes are now given the recognition they were denied for so many years. It is my hope that a history of impunity for gender crimes under international criminal law will be replaced in the future by accountability and deterrence and prevention. His hope has come true only in part, in my opinion, because obviously there is no doubt that the adoption of the ICC statute represents a great progress with respect to the possibility of prosecuting a wide range of gender-based offenses. For the first time in international criminal law, the statute not only lists rape and enforced prostitution, but enumerates several specific crimes against humanity and war crimes, namely rape, sexual slavery, enforced prostitution, forced pregnancy, and forced sterilization. Additionally, both provisions include a residual crime covering similar acts of sexual violence, non-explicitly enumerated. This allows for the dynamic interpretation and application of the ICC statute. Furthermore, the statute criminalizes the crime against humanity of enslavement, with special regard to trafficking of women and children. It also includes the first explicit criminalization of persecution on gender grounds or as a crime against humanity. Clearly, this is an important step towards a more gender-sensitive international criminal legal framework. I have already mentioned some relevant procedural rules. I would like also to make a reference to the idea that the protection of victims should be ensured also by means of appointing advisors with expertise on sexual and gender violence. And the statute also calls upon the states parties to appoint judges with expertise on violence against women and children. The rules of the procedure and evidence require organs of the court to take gender-sensitive measures with respect to intimate witnesses and to provide training on issue of sexual violence and gender sensitivity. It is a very topical issue also for our judiciary. And another important development is the inclusion of the term gender in the ICC statute, because Article 21 provides that the application and interpretation of the law must be without distinction founded on the grounds of gender, among others. It prohibits gender discrimination. Gender is defined as referring to the two sexes, male and female, within the context of society. But despite of this progressive legal framework, the practice concerning the prosecution of sexual crime is with many problems, because after 2 decades from the establishment of the ICC, only a single final conviction for sexual crimes was held by the court. And there are several reasons for which the sexual violence charges have failed. The first one may be identified in the lack of prioritization of investigations into this form of crime. The second one is the possibility of having a double standard, because in some cases there was a reluctance to hold leaders accountable for such crimes committed by their subordinates, just in cases of sex violence, while a different approach was adopted with reference to different forms of international crimes. Another problem is the misunderstanding of sexual violence. A typical example is the case against Uhuru Muigai Kenyatta and Francis Kirimi Mutaura, where a too narrow definition of sexual violence was adopted. In any case, there is a general opinion according to which the ICC has made significant progress in prosecuting sexual violence in its more recent practice. Some specific cases may be meaningful. In 2018, 16 of the 26 cases brought before the ICC included charges of sexual violence. And 2 recent judgments can illustrate a real progress in the practice of the ICC, because the court adopted a final conviction for sexual crimes in the case against Bosco Ntaganda and convicted Dominic Ongwen for the crimes of rape, sexual slavery, forced pregnancy, and forced marriage in another inhuman conduct. There was an innovative, gender-sensitive interpretation of sexual crimes that is being put forward. In my opinion, there is a hopeful trend towards a more inclusive interpretation of sexual crimes, because both the convictions of Bemba and Ntaganda included the rape of male victims. And the trial chamber clarified that the crime of rape under the ICC statute is gender neutral. The case against Ntaganda is significant also with regard to the treatment of intra-party sexual violence as war crimes, because among other crimes, the trial chamber convicted Ntaganda for rape and sexual slavery of forcibly recruited children, soldiers, as war crimes. In the past, the appeals chamber has decided that the ICC statute does not exclude members of the armed group from protection against acts committed by members of the same group. And the approach put forward by the appeals chamber allows for the prosecution of the intra-party sexual violence as war crimes, and thus closes an accountability gap in international criminal law. I think that in addition to these aspects that are closely connected to the legal framework and to its implementation in practices, there is also another aspect that deserves to be underlined, that there is an important trend towards specialization in the investigation in crimes, in international crimes against women. I think that some example may be significant. They are taken from the recent experience, because it is typical so that victims may need time to open up to an investigator. They want to tell their stories in their own way. They use euphemism to describe sexual violence. They fear retaliation for speaking to an investigator, and they can be re-traumatized by sharing their stories. And there is an important trend in the practice just concerning the attitude of the investigators, who should first allocate sufficient time for interviews based on a gender-sensitive investigation plan. They should use interview techniques that empower the survival. They should understand the local language and the context. They should ensure that witness protection meets the needs of the survivors, of the victims, and they should refer survivors to support services established within the social context. I think that these rules are very important in order to reconcile justice with humanity. And in my opinion, that's the real meaning of this new trend in international criminal law. in my opinion, the potential of the justice system to rebuild a relationship of trust with the society depends on its ability to find in the international culture of human rights the essential basis of all its interpretation and application of the law, and of its own organizational structure. Fundamental rights have become the common language of the present era. Faced with the challenges of multiculturalism and globalization, the world of justice has the difficult but fascinating task of rebuilding a unitary cultural base focused on the protection of fundamental rights, seen as the common denominator on which to build the dialogue between the different identities. I think that the recent development of international criminal law goes just in this direction. Thank you so much.
Dr. Balsamo, thank you very much for this highly interesting insight. I'm sure you have enjoyed it as much as I have done. I would nonetheless kindly ask you if you have questions to save them for later, to give our other two speakers enough time for their presentations, and we will collect and resume at the end of this first panel, which gives me now the opportunity to introduce to you our next distinguished speaker. This is our very well-known Professor Strand from Sweden, and she will talk about the topic that is unfortunately still very present nowadays, unfortunately also in Italy, and this is about crimes against women in time of pandemics. So Professor Strand, the floor is yours.
Thank you very much, and thank you for letting me have this speech. So I got the task to talk about this small topic, which is huge. And when preparing for what content, I decided to talk about domestic violence, since most of my research is on domestic violence. So just wanted to talk a little bit on gender-based violence. So I'm a criminologist, so there will be nothing about laws in this presentation. I hope you can follow me anyway. And just to put some context into it, so intimate partner violence could be any type of violence. And due to the Istanbul Convention, then the physical, sexual, psychological, economical violence and other types of violence are part of the research that we do. And I will especially add that rurality is one of my research area, and actually Italy has published some research on rurality, which I think is something that we don't talk much about. We usually talk about domestic violence when it occurs in urban cities and what we can do to help the victims where we have the access to all support. But there's an important question to raise, and I will come back to that. I also do research on the LGBTQI plus persons that also are part of domestic violence in different kinds. I also do research on honor-based violence, and when we talk about honor-based violence, that could be forced marriages, genital mutilation, honor killings, but also intimate partner violence as described above. Sexual violence, we have just heard very insightful thoughts about how to work with that. And this is just a small part of my work, but then stalking is something that I try to do more about. So coercive and controlling behavior. And all of these types of gender-based violence have had a rather big impact on the pandemic have had a large impact on that. So these are some numbers. As criminologist, I like numbers to show how many that has been victims and so on. So before the pandemic, then it's a well-established number that 1 out of 3 women have been globally have been victim of intimate partner violence. It's the same number as in 2002, 2004, 2013. So we do make a lot of effort to work preventive, but this number is kind of rock solid. So whatever we do, it's not working because it should change. And we do know that there's an increase among younger people, intimate partner violence, which it's due to many different things, but this is something we have to have in mind, that we need to work on maybe in another way than we have done before. Recidivism rates among IPV perpetrators range between 15 and 60% across studies. So it depends on how you do the studies. And when we do the studies, it could be in correctional settings, it could be police reports, it could be victim-based, self-reports. So it's all kind of reports. And even if it's 15 or 60%, it's very difficult to say how many that actually recidivate, but we do know that there are too many. And also, if they have been in contact with police or social service, there's still at least 1 out of 3 that will recidivate. So if society knows about the violence, we should do more. If we don't know it, because that's one of the questions that it's underreported, it's also difficult to do something about it. But since we don't do much about the violence we know about, then we can at least start there. And as I said, that IPV is also common in rural areas as in urban areas. And it has also been shown that femicide could be even more common in rural areas. The reason why we don't do more research or more risk management in rural areas is that there are fewer victims in numbers. But when we looked at and make differences on how many in percentages, there are actually more. So we still need to put a lot of effort into working with rural areas. When we looked into stalking in Swedish samples, we found that the majority of those reported stalking are women who are stalked by their ex-partners. And that's the same results. That there's a small study from Italy also, and it shows the same. And these are pretty much the 2 studies that have been done in Europe. So I'm happy that we could find something about this. And when it comes then to the pandemic, then I looked into some research, and they compared, which I think was interesting, when it comes to natural disasters, that something odd happens that really shake up the society, and everything you knew has to be changed. So the natural disasters are in small areas. I mean, who could have even thought of the pandemic 5 years ago? If anyone would have talked about that, we would have laughed, everyone, and said that's never gonna happen. You can't close the world, but we actually did. So I think the research done, it's important to actually have kind of an anchor to see what can we do and what happened now. So there was an reported increase after the earthquake in Haiti, 2010. There was a 47% increase after the eruption of Mount St. Helena. The psychological abuse was reported to increase from 33 to 45% after Hurricane Katrina in Mississippi, also in 2010. So we know that risk factors for violence are stress, loss of a job, housing, economics. All of those risk factors will, of course, increase when you have a natural disaster. And the worries about the COVID-19 impact on IPV has been many, but we think a lot of things, and so the UN Population Fund estimated that there would be about a 20% increase of IPV, which is an estimate, and also the pandemic in itself worsened women's economics. That's one of the worries, and the worries was both the loss of jobs, so that women don't have money to leave, but also less access to shelters and hotels. So if women would like to leave, there are no shelters open. All hotels are closed due to the pandemic. So that also was a worry. Where can women go? Job loss increases male frustration. That's one of the risk factors that we know about, and that might lead to aggressive behavior. So the most important risk, or some of the most important risk factors would be, as I said, loss of economics, loss of job, but also you lose your housing, and if you have all of these, the stress and the frustration increases, which also then increases mental health problems, which in itself is a risk factor. And it's also that it's not that mental health problems will by itself cause aggressive behavior and intimate partner violence, but there's a strong mediator, and that's alcohol abuse. So one other worries that were in the beginning of the pandemic was that alcohol abuse might increase. And then you might think the alcohol abuse, where we think people have severe problems, that was not the worry. The worries were those who use alcohol in a balanced level when they have to go to work. But if you have a Zoom meeting, no one will smell your breath, right? And if you're very hungover, then the technique can make, oh, I don't have any technique now, so you can't see me. Those things could actually make people cross that line. So when they can manage when they have to go to work, because work is so important, then that line disappear when you are isolated, sitting at home, and you might feel bored and think that, I might at least take a drink or two during night, and then there will be 4 and 5. But then anyway, no one's going to see me tomorrow. And those combination with frustration, increased alcohol use, and probably mental health problem, that's kind of a cocktail that will turn out to be really bad. Also, what we could see is that healthcare decreases possibility to admit help-seeking victims, because healthcare facilities were, well, this is in the beginning, so in March 2020, then everyone had to work with those who were sick. So there were very few that could actually go into helping victims if they weren't severely beaten, of course, but everything has to be towards the helping those who were sick from the pandemic. Just to talk a little bit about the theory that we like to use when we talk about intimate partner violence. So it's the integrated ecological model. So basically, as we think about it, there are many explanations to intimate partner violence, but we start with the individual in the middle. So it's always, you can't put responsibility on anyone else than the individual. You do have a choice to make when you abuse someone. Although there can be lots of reasons and explanations, but it's an individual that actually do abuse another person. Risk factors could be that the individual will be in a relationship. So within this relationship, there can be risk factors such as separation. We know when couples separate, it's a high risk for abuse. There's also other risk factors within the relationship, such as pregnancy. Some of the domestic violence actually starts when they are pregnant for the first time. And the individual and the relationship will be in the community. So there are also within the community risk factors. Here can be unemployment, it could be your social status and where you live and all of those things that you have to live up to. And sometimes there's a frustration here. So as I said, lack of economics, if you lose your job, you lose your house. And if you then also have problems with how to deal with a conflict, or you're in a separation, then that will add. So it's the interaction between these things. And the societal level is our the laws we have, the norms in society, and which also means that you can have different norms, different laws that affect the society, that affects the relationship and the individual. So what happened then when we actually had the COVID pandemic was that we just put a lid on all of this. So isolation on everything, meaning that the individual or the relationship, they are now stuck with each other. And what we have found is that actually we made the world rural. Because the same isolation that individuals experience in rural areas were now put on everyone in the whole society. And since we don't have much information on rurality, we couldn't really use the results that are from there. So what happened then? Well, the World Health Organization reported 5-fold increase on calls for helplines from April 2019 to April 2020. So there was a huge increase in the calls. There has been increase of violence in China, Italy, Spain, France, and Brazil. But it's extremely difficult to say if it actually increased and how much it actually did. And I will come back to that. In the UK, they could see there was an increase of femicide due to domestic violence during a short period of time of domestic violence. But the cause of the violence could not be linked to the actual violence. There's a research that shows that the abuser limit the access to help and support for women, so that they take their phone basically, or take their computer, so they can't get access. And the society have just put a lid on the rest of it, because you can't go out, you can't seek help in a way, other ways, due to social distances and all of those things. There's also research that show that high anxiety by females to be due to the pandemic actually increased abuse, while having a job for men decreased abuse. So if men still had their job, then that decreased abuse. But then there were also research that showed that if you lost your job, then the frustration increased, and then also abuse increased. There's also this very specific risk factor for domestic violence that we never had before, and victims actually are afraid of the virus. So they rather stay in the abusive relationship than leave, because they are more afraid of getting the virus than being abused by their partner. And one thing to have in mind is that there were a review done in 2021 by Verdu, and most of the published data derives from social media, internet, anecdotal evidence, and helpline reports. So there haven't been many real research studies that really have investigated the cause of the violence, and if those things actually changed. There are a few studies on that comes from police reports, because what we also can see is that police report decrease, and that we think is due to difficulties leaving your home, or be on the phone and so on. So increase or decrease of violence, I would say it depends. So one of the things we have to establish, what do we actually mean by increase? Do we mean that more people are being victims? Or are we, could we mean that it actually are more abuse within already abusive relationships? Because this is something that we don't really know. What we do know is that it could also be a decrease of violence due to less interaction with others. So one motive or one risk factor is being jealous. So the partner being very jealous on the woman, and then commits the violence because he suspects that she's going out with someone else or looking at someone, and she stay at home all the time. So then they are not jealous in the same way as before. So some women actually, anecdotal then, talked about, well, the violence has decreased during this time. The isolation also reduced the possibility of insight from others, which means that the violence can be much more severe than it has been before, because for some women, going to work is their safe place, because then during the day on their working hours, no one is abusing them, and they also have the possibility to talk to others. We know that there are abusers that when they hit the woman, they will do that in places where it can't be seen. So they will have bruises on their backs, and they will have bruises in front of their legs, because those are areas you normally don't show when you go to work. When you don't have that, you can also have technical problems on Zoom due to this. If you have been beaten, then you can also have technical problems because you don't want to show that you actually have marks in your face, for instance. We also know that there are less help seeking from older victims and more from younger victims. And one can wonder how that comes, but it's rather simple, because in my generation, we do have a phone, we do use them, but we use them to call. We don't have our lives on our phones, which means that if someone take my phone, then I won't be able to call anyone. But my friends wouldn't be scared of something happened to me just because I don't have my phone. If you're in your 20s and you lose your phone, you will have an emergency call after an hour, because now you're not responding to lots of things that you are responding, which means that younger people, they have access to their phone. The abusers cannot take the phone, because then someone will recognize there's something wrong here. So then they can use the apps, and there are lots of actually really good apps for getting help for domestic violence. And the younger ones, they know how to use them. But in my generation, we don't know really how to use them. And we are a bit too skeptical and a bit too afraid to make contact also in that way. So we think that that's one of the reasons why the younger victims have sought help more often. Risk assessment and risk management were also more challenging due to the restrictions implemented to stop the pandemic. So even if victims reported violence, the police couldn't do much. They less people to take care of the risk assessment, and also they need to do other things. And as I said, for hospitals, social service restrictions makes it very difficult for them also. And especially hospitals that cannot take anyone else than victims of the pandemic, which also then made it very difficult if you were severely beaten. So this is my last slide. Just some reflections that I took from this, I think, a very good review. But one of the things, the stay home, save lives mantra that we have heard for these years, protect the public from COVID-19 infection, becomes a paradox in the context of domestic violence, because it actually increases violence and can increase death due to the violence. And also, while quarantine is an effective infection control measure, it can lead to significant health, social, economical, and psychological consequences. So COVID-19 and violence against women are interrelated pandemics. And I think that's one of the really good things that I read about this, that they actually use the word pandemic about gender-based violence, since 1/3 of women around the world are being the victims of gender-based violence. We really have to think about that as a pandemic, because it has severe health questions as well. And it is a complex problem for society to deal with, and the pandemic has revealed more risk factors and vulnerabilities that we need to address in new arenas. So that's actually, if one can say that, a good thing that we can continue to work with after the horrible times of the pandemic. So thank you very much for your attention.
Professor Strand, thank you very much. This was also highly interesting, and I'm pretty sure that many of you now look at the pandemic from this new angle, because it's still fresh on one side, but on the other side, this was a whole new approach and a whole new perspective. And before we get to our third distinguished speaker, I would just like to recall that this conference takes place also online. So we have a very nice number of persons who are attending online, and I would also invite them to remember or write down their questions for all of our speakers, and then to ask them at the end of the first part of this panel. And now, by this, we're coming to our third distinguished speaker today. This is Professor Filippo Romeo di Unicore, and he will talk about civil remedies, a very Italian topic coming, but also interesting for us from other countries, for victims of domestic violence, the innovations introduced by the law number 206 from 2021. Obviously a national law, but we're curious to hear from you the implications and maybe to take some of them into our legislation. The floor is yours.
I thank the organizer, and in particular Gabriele Carapezza Figlia, for this grateful invitation. I am very pleased to participate in this panel. In my presentation, I will talk about civil remedies in favor of victims of domestic violence, and in particular about the change introduced by Law 206 of 2021, reform of the civil process, and by the implementing legislative decree adopted by the government last September 28, 2022. This subject is a very sensitive and of stringent actuality. Over the years, as coordinator of the legal clinic in protection of weak individuals and handling of family conflict, I had the opportunity to verify, thanks also to the collaborative relationship with Anti-Violence Center, the transversal nature of the phenomenon that does not belong only to degraded context, but also to high social class family. Having said that, I should be mentioned that back in 2001, the Italian legislator, amending the civil code, introduced some protective measures to suppress the domestic violence. These measures are now placed following the reform in the ritual code under a specific title dedicated to proceedings concerning persons, minors, and families. The intervention of the legislator have not been modified by the reform, and it's even today effective for the flexible nature of the protection order, both from a personal and patrimonial point of view. The discipline, in line with what happens in other European legal systems, is characterized by the separation between the civilistic measures of protection and the criminal measures of the repression, by procedural forms aimed at the celerity of the decision and the effectiveness of its implementation, for the shortness of protection measures, for the variety of the protection measures, order to stop violent conduct, removal order, prohibition of approach, economic measures against the violent person. With regard to gender violence, in order to stem the phenomenon, the reform has dedicated some specific provisions to cases of domestic violence during family disputes. Several are the issues to be considered. First of all, it should be noted that the reform legislator, in line with Article 48 of the Istanbul Convention, excluded the possibility of resorting to mediation in the presence of cases of domestic violence. It's believed, in fact, that violence does not allow for a condition of balance between the parties in the construction of the mediation setting. The choice made by the legislator in 2001 was different. The adoption of the protection order, in fact, did not provide for the absolute exclusion of a mediation course for violent party. The judge, therefore, could order the intervention of social service or a family mediation center. This choice, distinguished between cases of habitual and episodic violence, is more correct. In particular, an urgent, omitted all formalities assertment in the constant of precautionary proceeding does not guarantee the adequacy of the measures, which moreover could severely affect the parent-child relationship. The second issue concerns the directive principle elaborated by the reform appear to be in line with the regulatory provision in force in Italian legal system, and in particular with the novelties introduced by the Red Code, also with reference to the transmission by the criminal judge to the civil judge of the acts of relating to criminal proceeding for crimes of violence, in which precautionary measures have been taken against one of the parties to ongoing proceeding having as their object the separation of spouses, the custody of children, the parental responsibility. Also, from the standpoint of coordination between the civil and criminal courts, it's appropriate to highlight that the reform, disregarding the wishes of the Ministerial Commission RISO, does not place a burden of information on the parties, but aims only at institutional coordination between judicial authorities. However, in any case, it's not excluded the valorization, the duty of information of the party, the civil judge, full finding autonomy and his critical sifting, thus avoiding an automatic adjustment of a family judge measures with the criminal finding. Moreover, in the Italian Supreme Court has affirmed that the civil judge is not bound by the measures adopted by the criminal judge and must independently ascertain with full investigative powers the allegation of facts of violence. Another relevant issue concerns the allegation. The concept of allegation could have a very broad scope, as it could refer not only to violence alleged or reported, but also to facts of violence merely reported or referred to. In this regard, it's dangerous to exclude the relationship between the allegedly violent parent and the child in the presence of a merely reported or referred fact. Without a full investigative inquiry and scrutiny by judge, there would be a dangerous fallout on the principle of due process. The issue is sensitive. Also, with a view to protecting the parent-child relationship, full judicial assertment is needed where measures are be taken concerning the custody of placement of children, the regulation, the limitation of determination of the parental responsibility. Equally relevant issue concern when the validity of the allegation is recognized, the judge must adopt the most suitable measures to protect the victims. That said, legislator choice to explicitly mention protection order for the victim's protection of violent conduct within family units seem appreciable. Not less important is the issue of the secondary victimization. In order to ensure effective protection of victims of violence, the reform is noted for the provision avoid hateful secondary victimization, the shortening of procedural deadlines. It's crucial to provide quickly adequate response to victims of violence. The circulation of acts from the criminal to the civil court in implementation of the principle of Article 31 of the Istanbul Convention require the civil judge to consider the family context in which acts of violence took place. The child in turn may remain a victim for a second time within the framework of the process, in enough to think the cases in which his or her hearing is ordered several times and in different venues. Looking at the provision on violence contained in the reform, first issue related to child refusal to meet one of both parents. Behind this refusal generally lurks an impairment of the parent-child relationship. The fact takes on particular relevance with respect to minors of adolescent age. In these cases, the child shows his or her refusal very clearly, but very often is unwilling or unable to explain the reason of the refusal. In such a situation, it is very important for the judge to listen directly to the child. In this regard, the reform excluded listening delegated to technical consultancy, social service, as well as an honorary judge. That being said, inappropriate to turn my attention to sensitive issue of listening. In this regard, the judge have often shown that they fear listening. It's not easy for the following reason: finding the right approach in order to verify the child trustworthiness, to distinguish to the true from the false. The child does not lie, but describe a lived experience derived by an imaginative process. Check whether the child narrative is impermeable to parental conflict. Considering what about said, it might be useful for the judge to assist at the time of the listening by a psychologist. The support of an expert could be particularly important given the difficulty of bringing out the violence within the family, understanding the family dynamics, grasping the boundary between conflict and violence. In any case, it should be pointed out that few courts have a courtroom for listening to the child, equipped according to the provision of Article 38 bis of the implementing provision of the Civil Code, namely with audiovisual system and one-way glass. More often, therefore, the listening takes place in the judge rooms, thus disregarding the possibility to allow the parental counsel, the minor special curator, and the public prosecutor to follow the listening in a different place. That said, it should be pointed out that most courts exclude the participation of the parties, defense counsel, parent, special curator, and the prosecutor. Normally, this figure can only give to the judge the question himself which will ask to be child. The reform stipulates that the judge, to endorse the assistance of a consultant must proceed by a reasoned order indication the assertment to be made and the measures necessary to protect the victims. This clarification appears important. Often, in fact, there are cases in which, without this being part of a judge mandate, the consultant report goes so far as to express evaluation about the parent's personality or their parental suitability. This practice, moreover, appears to very dangerous because judges tend to accept the consultant conclusions. The provision under comment, moreover, also appears important with reference to acts of the violence through the expert operation or investigation carried out by the social workers. It will be possible to bring out violent conduct. In this regard, it should be mentioned that in the constant context of the family process, counseling is always psychological. The psychologist will assess a relationship with the family. Moving quickly to the conclusion, I express a positive opinion for the provision made by the reform on domestic violence. In particular, it deserves attention, the express reference to protection order as measures to be taken for the protection of victims of violent conduct, to give to family dispute marked by acts of violence a fast track with a reduction of procedural deadlines and specific provision to avoid the secondary victimization, having given convincing answer with respect to delicate issues such as the hearing of the child by the judge, the duties of the counselor, and the perimeter of the relationship. Through a full judicial settlement entrusted to the specialized judge, supported by experts, the reform will provide more effective response to the protection needs of victims. In conclusion, I would like to stress the importance of the specialization in the field of family law. Highly specialized judge, lawyers, and counselors are also needed in order to be able to properly govern the complex family dynamics, especially during parental conflict. Thank you for your attention.
Professor Romeo, thank you also very, very much for your highly interesting presentation, which was about a national topic, however, has in the end a more broad frame and approach to be regarded within. Now we are perfectly on time, actually, and now comes the moment for you to put your questions, either here or if you are present or from the participants online. So please, the floor is now yours for questions or maybe only comments, suggestions, etc. Please feel free. Here comes the obligatory minute of silence. Who wants to break the ice?
Chiquina? Just a small consideration. Before all, it's my big pleasure to be today here because I was working in this project. So now I can see the result of this big effort. But just I want to ask to Professor Dr. Antonio Balsamo, because through your experience, for sure that is in practice, do you think that, because this is my impression and also through the reports, there is some lack, some way in the preparation of the judiciary in the application of the law? For instance, sometimes there are some problem when you have to interpret about the burden of proof in civil. Just my impression, but also you can see through some recent judgment, ITA, for instance, ISA case. And I think this our commission is our need to work with the juries in order to increase the preparation about EU law, international law, for the implementation of gender equality.
And in my opinion, we have to do something more. But for sure, you know, because you are in the position and you can do something in your charge. But I would like to ask to listen to you.
Yes. Thank you. I fully agree with you because I think that the professional training of judges, prosecutors, lawyers should be improved just in a way that is consistent with the need for protection of fundamental rights of most vulnerable people. Because there is a lack of awareness about the real needs.
I don't want to say so general, I don't want to say, but I think that something has to be done.
Yes, I also think that much has been done, but much is still to do in the next future, because there is a problem of language and the problem of culture. The problem of language has been addressed by the European Court of Human Rights in some recent judgment that has underlined the need for using words that prevent everyone from a new victimization. And it is not only a formal issue, because behind the language there is a way of thinking. And in this respect, I think that a full awareness of the indications coming from the ICC statute may be very useful. For example, there are some specific rules included in the law provisions applied by the International Criminal Court that can play a crucial role. I would like to mention some of them before. I did not go through this topic because of the time, but just making reference to your kind and interesting question, I think that it deserves to be underlined. For example, there is just in the regulation applicable to the International Criminal Court, something that can be an advanced approach, because just a moment, I would like to mention these points. The rules of procedure and evidence state, for example, that consent cannot be inferred by certain circumstances, such as the victim's words or conduct under coercive circumstances, or the victim's silence or lack of resistance. Furthermore, credibility, character, or predisposition to sexual liability cannot be inferred by the sexual nature of a victim's prior or subsequent conduct. And evidence of the prior or subsequent sexual conduct of a victim or witness shall not be admitted. These are rules that can be very important also in our criminal procedure, in my opinion. It is no case that just these topics were addressed by the European Court of Human Rights recently. The European Court of Human Rights in a recent judgment condemned Italy for the language and for the thought behind. I would like to add some decisions that were absolutely inconsistent with this approach. In my opinion, there is also a more general issue of protection of victims, starting from women, because the idea of assistance to victims should be understood in a more comprehensive way. it is not only a matter concerning the development of a criminal procedure. It is also a matter of organization of justice. We should try to create some environments that may be comfortable, convenient, immediately accessible to victims. There is a project that I would like to carry out in the Tribunal of Palermo in the next few years, just about the assistance to victims, to be ensured by means of cooperation with the civil society within specific premises that are outside the courtroom. There are some premises in the city center that are also near to some areas that, in my opinion, should deserve a stronger institutional control. And just there, I think that the premises of these services could be located. I think that this is a good opportunity opened by the new approach underlying the reform of our Code of Criminal Procedure, because the idea of restorative justice is in full compliance with this way of thinking, with the victim-centered approach.
It's an effective way to increase the access to justice.
Yes.
This is to increase how you will increase access to justice. This is a way you have to start to be near to the civil society and to offer place, to offer consultants. And no, there is a big distance. There is a big. I was surprised in Peru how the judges work in a rural area in order to increase and to help vulnerable people, women and minors. So to work in the street in a sense, sometimes.
It is a very challenging issue for us as well. I think that this could be an experience to take into account, also because we have to deal with the people located in several different areas, and also difficult areas of the city, of our region, of other nations. We should also try to understand the point of view of people coming from other countries that have experienced terrible times, and they should be understood in depth, in their soul, I would like to say. And I see a strong similarity between your approach and the way you're thinking of a great judge, Mr. Rosario Livatino, who spoke of the trust that should be increased just by being closer to people. It is no case that this meeting has been organized in particular by Professor Carapezza Figlia, in which I see many of the values that inspired the life and the work of Mr. Rosario Livatino.
For those of you who are online and who have maybe not heard the question, you heard the answer. The question was about the access to justice, but I think you understood that already. Thank you very much for the questions. We have another one, please.
Yes, hello, I'm Elena Christopherson, professor in law from Orebro University, and I have a question for Susanne. I wanted to ask you whether there is any research on women who have actually left during the pandemic, because one could, I mean, you give quite a sad picture of it, but one could also expect maybe that those women who actually managed to leave, that it would be more difficult for the men to go after them in the times of the pandemic when there was a lockdown and so. But I don't know if that is something that has been researched upon. So I wanted to ask you about that.
Well, thank you for your question. I wish I could say that there were research on this. What there are some indication of those is that stalking has increased, which means that he doesn't care about the restrictions if she leaves. And there are difficulties for women to, well, first of all, to leave or get access to a hotel or apartment, or even to move in with their relatives due to the restrictions. And if they manage to do that, I can't say that the research on it, but we do know that stalking have increased to some extent, since they don't care about the restrictions to get the ex-partner back, or would be more important. And since there are no one that actually stops them, which in a normal case, they can go to a shelter and then they will be stopped. That has also decreased. And what we have seen is that there has actually been shelters that has openings. So there have been spaces available, but unfortunately, women haven't taken the opportunity to leave and to be safe at those shelters. But it's a very interesting research question, and I will look into that even more. So thank you.
Marco, did you have a question? Please, go ahead.
No, I prefer to go there. I think there is a connecting factor between the three lectures we had this afternoon. We had the pleasure to hear this afternoon. And this is from the point of view of a scholar who does not deal with internal law, or rather with international law, is the weakness of the possible obligations flowing from international law. The rising of cases of domestic violence during pandemics makes it clear that there is a problem of eradicating those stereotypes, which have been the ground floor for domestic violence. On the other hand, the difficulties in handling with victims of violence or witnesses, once again, flows from the difficulties states face in applying those, in complying with those obligations flowing from international treaties, such as the CEDAW. The CEDAW committee made it clear in several recommendations there are certain specific obligations in order to protect women who were victims of violence, but almost a few of them are now part of domestic law, which is not only a cultural problem, but it's a problem of the weakness of the system as a whole. And if you consider the way in which Italian law has regulated the protection of women victims of violence, but we might find there are still obligations the Italian state has not complied with. Things become worse and worse if we take into consideration migrant women victims of violence, because the law, as it was established, either international law or at EU law, considers the problem as a problem of control of migration flows. But we might move from the way in which trafficking is defined by the protocol, the Palermo protocol, or the way in which the Directive European Union has adopted regulates permit of stay, which both of them are intended not to contribute to protect women who are victims of violence or trafficking, but rather to ensure states' interest in taking control over migration. So this was just some thoughts, the flow from your very interesting lectures.
Thank you, Marco. We have another question here, please.
Let me introduce myself. I'm Andrea Mattarella. I study criminal law, and I have to say I'm pleased to work together with Professor Antonio Balsamo, and thank you for the meeting of today. Just to consideration about the meaning of this topic. When we speak about criminal law, of course, first of all, it's important that to have a common framework at the international level, because it's not possible to prevent such a criminal issue by the single countries, but it is important to have a common framework. Of course, we can recall the provisions, as it was said, of the Palermo Convention and other international instruments. And second, I think that when we speak about such an issue, criminal law is not enough. I mean that to punish is important. To have an international criminal law is also important, but even more important is to work together with the civil society. We have to worry about not also guilty people, but also about victims, as it was said, in order to prevent secondary victimization. And of course, criminal law is not enough because we have to work together with educational institutions such as universities and schools, especially because we talk about relationship between genders. And in this sense, I would like to underline that our university, LUMSA, joins the works of the United Nations Convention about cybercrime, which is a clear example of the important work between the institutions, the civil society, and of course the criminal authority. And because this is an important consideration about what criminal law can do and what criminal law can do by itself.
Thank you very much. If there is no other question, I would like to add on this, what you have just said regarding the UN Convention on Cybercrimes. And in general, we have seen that during the pandemic, but also in these modern times when everybody uses their smartphone for communication, for paying anything. It has become an integral part of everyday life, that the crime scene becomes more and more online. So this is something that has to be taken into account even more. And we know from, especially of stalking, that this is a huge issue which may be regulated, but it's not really prosecuted, I would say, in the right way, not even if the legal framework is a good one. And also what you have said regarding the common framework at the international level, and I go back to what Dr. Balsamo said regarding also the tribunals and the ICC, the Rome Statute. The problem in general with international criminal law is that the sources are not ratified by all countries, meaning that we have some particular points of reference regarding former Yugoslavia, regarding Rwanda, regarding the Rome Statute, which is, as we all know, not ratified, but I dare to say the most important countries in this regard. And also regarding the actually good framework of the Istanbul Convention. Not only are there no new parties, we have even now the problem that one important party has even withdrawn from the Istanbul Convention, as we know. And this is, I would dare to say, a trend right now, that the people, although being aware of the necessity to cooperate on the international level, leave their national interests first. So me first, my country first. So I would dare to say that this will be a challenge not only for domestic violence against women, but also in general for all other types of violence. And also regarding the ICC, there's this problem of we have only a few cases, and the majority of them are actually concentrated on only one continent. And then we have this development which is also pointed only on one part of our world, while the others seemingly develop in another direction. This was just one thought of mine.
Yes, because my considerations come from a deeper analysis of the function of criminal law, because when we study criminal law, of course, Italian Constitution speaks about re-education. So, of course, when we speak about gender violence, it's not enough to punish, but we have to think about re-education. So we cannot analyze this topic only by the side of punishment, but we have to think about the participation of other sciences, such as sociological criminology. In this sense, I come from a visiting period in Oxford where I studied criminology, and it's a matter where you clearly see that there is a deeper connection within the crime and the guilty people, because you have to analyze the culture which is the base of the crime. So it is we need a multifunctional approach.
Exactly, and what you're talking about is actually one of the basic characteristics of criminal law, and this is that the criminal law is the last instance. It's the ultima ratio. It's not the prima ratio. It's the ultima ratio. But currently, also in the country where I come from, you only hear calls for more punishments. It's not that the legal framework is bad. Maybe the prosecutions are not sufficient. That would be rather the case. But nonetheless, we have this development of penal populism, not only in at least in my country, but also in other countries as well, especially when it comes to sexual crimes. And so this is something that has to be tackled as well. I have a question for Susan, if I may. And this is regarding, you showed the integrated ecological model. I find it very interesting. And my question would be, are there in any way customs of a certain society integrated, or have there been any surveys on this, especially regarding the pandemic, if there was it taken into consideration anywhere? So customs, not only the legal framework, but the informal one, so to say.
Okay, thank you for your question. So the integrated model actually says that a motive for the violence is the interaction between these different levels, which means that for one couple, there could be only individual and relationship problems. What happens in society doesn't affect them that much. And for other couples, it could really be the difficulties with the issues that will happen on community level or societal level. And if I understand your question correctly about different customs and if there will be differences, and then I would say that is the point of the model, that you can have in different societies, different levels are more important. So if you have a very strong state, or you have a very strong norms in the community where you live, then that will affect the domestic violence to a higher degree. But it is the interaction between. And I was said with the pandemic, then since the interaction between individuals and society will be less, then also that will have less effect. So it will be more that the individual and relational factors will increase, since there will be no help to address those questions. But for instance, if you have problems, or if you get justified in your violence by others in the community, that will be less of that during the pandemic, because you won't meet them to the same degree. So then that risk factor will to some extent decrease, and then the individual and relationship risk factors will increase.
Thank you very much, Susan. Do we have other questions? Please.
Just a comment on the interesting place that I noticed on by a new role of a transnational criminal law is ongoing, just in this area of gender specific crimes, because it's not case that a new approach to international cooperation was developed by the European Court of Human Rights, just with the reference to cases concerning trafficking in human beings. It is the landmark judgment held by the European Rights. In the case of Luxembourg status and function, that changed our way of understanding the meaning of international judicial cooperation, which is no longer considered as a merely governmental process. It is now one of a possible obligations stemming from the protection of humanity. The concept of international cooperation changed in the case concerning trafficking in women. And a possible future development of transnational example was underlined in the working groups of the Palermo Convention, in the working group concerning trafficking in women, especially 2 years ago, when they did a form joint investigation bodies making use of modern technologies was highlighted because when we speak of joint investigation bodies, we say something that is a different meaning from joint investigating teams. Investigating teams related to specific cases and related to why the investigation bodies may have a permanent structure and may deal with the categories, with the types of crime. I think that the forms of intervention are changing due to the government action in the area of the implementation of the Palermo Convention. And this may open a new perspective of cooperation between the EU member states and the third countries. There are some interesting ideas about the establishment of a cooperation box between the countries, member states, and outside the European Union. Perspectives be taken into account with such attention. It is a way of building the future of some ideas that were the most important moments of our history when we tried to adapt the organization of justice to the dimension of organized crime. Because the words of justice before
Thank you very much for the comment. Do we have other questions or comments, online or offline? Please.
Good evening. I am Dr. Mignano. I am a PhD student on European Union law. I have a consideration, a question for Professor Balsamo. For me, he's a professor because he was my professor of criminal law. So we have within the European Union a new particular institution, the European Public Prosecutor Office. We know that this institution, of course, can act in order to protect the financial interests of the European Union. So his range of action is very broad, is very limited. But according to you, can member states one day decide to pursue some crimes such as not only money laundering, but of course human trafficking and all these kind of crimes against humanity with this particular institution? Because I think that in an integrational perspective, the European Public Prosecutor Office is a clear intention of member state to pursue a common criminal interest, a common criminal action against these crimes. Thank you, Professor.
Interesting question. I hope so, because there are some interesting proposals about the extension of the competence of the EPPO, of the European Public Prosecutor Office. One of them refers to terrorism, which can, at first glance, it could be seen as something different from the topics we are dealing with now. But in fact, there is a clear connection between terrorism and crimes against women. An example taken from the recent experience, UN investigators found a new area of international crimes against women, just in close connection with terrorism. It is the case of Yazidi women that have been exploited in Syria. And there are clearly ongoing investigations. But I think that the proposal made by some states, including Italy, for extending the competence of the European Public Prosecutor Office to the phenomenon of terrorism may open a new horizon that includes also international crimes against women in areas where the institution of states have a difficult moment of reconstruction. That's an area where the intervention of the European Union could be important in several aspects, because the idea of protection of women cannot be limited to criminal trial stricto sensu. It should be also understood in such a way to include material assistance, cultural approach, sustainable development, all those topics that are covered by the Palermo Convention and its protocols, including that on trafficking in human beings. Many thanks.
Thank you. I would maybe especially underline the cultural approach, because I think this is something that needs to be tackled in the future very much, especially as we are more and more merging together. Sorry. So this is something that is sensitive on one side, but on the other side, it is something, maybe some kind of soft skill, but nonetheless, it will be necessary. Do we have further questions or comments? Professor Vujadinovic, please.
Thank you. So, Dr. Balsamo, I do not have questions. I just want to, because I'm not enough competent, but I was impressed with your presentation as well as with your comments, and I a little bit envy Italian judiciary and system, because I really, with difficulties, could guess who among judges and in the frame of judiciary could have had such a high level quality of gender awareness, gender competent and gender sensitive approach. So I really was impressed. I think that Serbian judiciary has to do a lot in order to reach something, at least something of what has already been reached, at least in what we could get and witness from your presentation. So thank you very much. And I liked, Susan, very much your presentation, and it's so good when you pandemics, violence, pandemics, gender-based violence pandemics with COVID violence, and when you use that notion, be safe, stay at home, and mantra, and deconstruct that, you show how that mantra, what it really means from the point of gender-based violence. Ivana asked you about that integrated approach, which is very nice, very fruitful, but what maybe I would add something, because I have been in the process of writing the paper about pandemic crisis and rise of gender inequality, including rise of gender-based violence. And there I use 3 premises just to mention them. So each crisis contributes to the rise of gender inequality, including the pandemic crisis, because the patriarchal matrix gets more, how to say, impact in the everyday life, and that emancipatory side of the real life has become suppressed because the survival and the bringing women back to home. So that logic. So each crisis, environmental crisis, natural disasters, and COVID, so all crises contribute to this balance, rising this balance between patriarchy and emancipation. And then I also use two premises. The one, again, patriarchy, so men still do think and act as that women are their property, that they can do what, stalking, killing, and whatever. In Serbia, we really have the pandemics of femicide, the rise of that, and the high numbers from year to year. So that has some, and also I think what could be the causes of, additional causes of the rise of violence. There is the crossing between these contradictory tendencies. Some of the partners or some segments of societal life do contribute to patriarchal tendency, and some others, including emancipation of women in the particular partnership, couple. So they contribute to the rising clash, and plus pandemics, frustrations, etc., etc. So I think that all of these contributes to the rise of violence, gender-based violence. Maybe you agree, maybe you don't.
Well, thank you, Dragica. I do agree to some extent, and research do show that in countries where you have lower inequality, then if women get a job, get more money, and then violence will increase. So that's absolutely correct, that it will be a backlash. On the other hand, in other countries where equality, gender equality is more worked with, and you have a higher rate of gender equality, it doesn't seem to have the same effect. So because women have income, and they can also afford to have an apartment, and they can afford to. So that's why the integrated model is so good, because in countries with lower gender equality, the structural, the societal will be so much stronger that it will, so to say, go to it will affect every part to such an extent. But on the other hand, in countries with higher gender equality, we do have laws that should prohibit gender-based violence, but we still see in practice that it doesn't. So what they say is that it's a very complex phenomena, and that we have to work on many arenas to help victims of gender-based violence. And I think our very research show that helping women in countries with low gender equality to have more money and to be able to leave abusive relationship, that's a very important start, but it doesn't solve the problem. Fortunately, so we have to work on many things. So I think in that sense, you're absolutely correct. It was a very good remark. Thank you.
Having in mind the time, this would be the last call for one last question or comment, if we have one. If not, I would like to conclude the first panel by just some, yes, please.
Just a moment. Only to some
siamo del post Strand, exchange of ideas, proposals, and the perspective for the future in my life. Very much from the Serbian in terms of energy, in terms of the ability to be firmly rooted in the international character. It is a real beacon of hope.
We're happy to hear that. And I would like now to conclude the first panel with just some highlights of what we have heard so far. We have heard 3 different presentations, and the first one was about international crimes. We've heard about their evolution regarding violence against women. We have understood why rape is not only an inevitable effect of war, but actually one of its weapons, and how it is targeted now in the right way, I would say. Then we heard about the problem of pandemics. And I was very surprised by this rock solid number that still 1 in 3 women before and after are still victims of domestic violence regardless. And also I would like to highlight from this presentation that isolation was or is one of the most powerful weapons in the arsenal of the abuser. And this is something that was handed down, literally gifted in this time of pandemics. And regarding the last presentation, what was pointed out, the necessity to avoid secondary victimization, the allegations of violence, which are now enough in those procedures, and also to take care of modalities in which a dialogue between the civil and the criminal court has or should take place. So 3 points I would see as connecting all those 3 presentations were, first of all, understanding of the language of the notions of rape or of the notions of civil procedure, interpretations and risk factors when it comes to domestic violence in the context of pandemics. So understanding, first of all, what is our basis. The second one, a holistic approach, especially regarding, for example, the last presentation regarding the collaboration between civil and criminal courts. And in the end, also some kind of specialization. So the picture, which is more narrow, as we have heard from your idea regarding the Tribunal of Palermo, how to tackle this issue at your court. So on one side, holistic, on the other side, but also on the point. Thank you very much for your presence. Thank you very much for your comments and for your questions. And by this, I would like to wish you a nice evening and see each other tomorrow. We continue tomorrow. Tomorrow at 9. Thank you.